You're watching House Habits with House Counsel. We're about empowering resilience and delivering practical solutions. Today, we'll explore how abiding by consumer law is not only legally essential, but also a key factor in building trust and credibility with your stakeholders. In Australia, businesses and even charities are bound by comprehensive consumer protection laws. They allow and ensure fair and transparent dealings. So some organisations get themselves a little unstuck when trying to entice customers, or in the case of charities, donors, without presenting factually accurate information regarding their goods or services. Today, we're going to focus on one area of these laws. You might have heard the term before, misleading and deceptive conduct, or misleading and deceptive representations. This practice can harm your reputation, it can erode trust, and more importantly, it exposes you to significant financial consequences and legal consequences. Section 18 of the Australian Consumer Law deals with misleading and deceptive conduct that can give rise to the misled or deceived party being awarded damages. And Section 29 of the Australian Consumer Law deals with misleading or deceptive representations of goods or services. The difference between these two, unlike Section 18, Section 29 can constitute an offence, resulting in some pretty significant penalties. So let's delve a bit deeper into what constitutes misleading and deceptive representations by looking at some examples. The Nurofen case. You might have heard about it, it was all over the news. ACCC and Reckitt Benckiser, Australia Proprietary Limited, Reckitt Benckiser released Nurofen-specific pain products and were represented as treating particular types of pain. In fact, these different products were exactly the same ingredients. They were accused of profiting to the tune of $25 million. Initially, a fine was imposed by the federal court, or a penalty was imposed by the federal court for $1.7 million, but the ACCC appealed this penalty and that was increased to $6 million. In another case, LG came unstuck in relation to how their representatives interacted with customers. They were found to have misrepresented to consumers what their rights were. In the ACCC and LG Electronics Australia Proprietary Limited, in 2019, the ACCC sought a pecuniary penalty of $700,000. Ultimately, LG was given a penalty of $160,000. The first issue in relation to this case was in July 2014, when LG representatives informed a customer that a faulty TV was outside the warranty period and therefore they couldn't assist them. Sounds like a pretty normal interaction, right? But you cannot misrepresent to your customers what their statutory guarantees and warranties are, even if you've got an express warranty that's to the contrary. And in August 2014, LG representatives also told a customer that they wouldn't repair a faulty television because it was out of warranty. These assertions misrepresented to the consumers what their rights were under Australian consumer law, specifically the consumer guarantees that override any explicit warranty given by the manufacturer. Jetstar was also hit in 2019 with a pecuniary penalty of $1.95 million for telling consumers that flights weren't covered by statutory guarantees or warranties. And even when you go into other industries, like car industry, for example, there's instances where a seller falsely claimed that the goods were new when they weren't actually new. There was a 20-month-old compliance plate on a effectively superseded model. That case was Henderson and Bowden Ford Proprietary Limited. And there was another case with Nissan in the Australian Competition Consumer Commission and Nissan Motor Company Australia Proprietary Limited. The manufacturer had advertised a car of a particular model in a newspaper, but the advertisement contained a picture of a car that wasn't the model being described in the advertisement. So it's really important that you understand the implications of falsely representing or likely to mislead or deceive consumers in relation to your advertising. It can be tempting for organisations to maximise profits by misleading consumers and claim they're just using the business judgment rule. Although the legal consequences are pretty clear from these examples, the long-term reduction in trust with stakeholders is very difficult to overcome. Organisations that communicate honestly and accurately about their products and services cultivate and enhance a trust relationship with their customers. It's about delivering on your promises. Big picture. Number one, avoid any ambiguity. Ensure your claims are precise, supported by evidence. Number two, be careful not to create false expectations. And number three, above all else, be honest and clear with your customers. You'll earn respect, you'll earn loyalty. Complying with consumer law isn't just about ticking the boxes, it's about building a strong foundation for your organization. By respecting your customers' rights, you not only avoid legal issues, but you can also gain a competitive advantage by being renowned as trustworthy. This builds advocacy for your organization and can lead to positive and incredible interactions, word of mouth interactions that build long-term value. So to wrap up, it's vital to understand and uphold the principles of honesty and transparency. And by doing so, you not only safeguard your organization, but also establish a reputation that does stand the test of time. This has been House Habits with House Counsel. Thanks for watching, and please don't forget to subscribe.